Good morning. The commission is on the record in case number 9702. This is Pepco's rate filing pursuant to order number 90634, which was issued on May 17, 2023. Today's the time and place for the scheduling hearing. The day before, on May 16, 2023, Pepco filed a request to review its base rates covering a 3-year period to extend its multi-year rate plan through December 31st, 2027. The proposed multi-year plan states that it intends to recover cumulative electric service revenue deficiencies of just over $17 million for 2024, $160.5 million for 2025, just over $193 million for 2026, and just over $213 million for 2027. Pepco's proposal also includes the acceleration of remaining electric tax benefits in the years 2024, 2025, and 2026. After applying those accelerated benefits, the electric revenue deficiencies become just over $74 million for 2024, just over $59 million for 2025, and just over $59 million for 2026. This proposed request would lead to an overall electric rate increase of 5% for year 1, 3.78% for year 2, 3.66% for year 3, and just over 1% for the 9-month extension period. We'll begin today by taking appearances of the parties, beginning with our staff. Good morning, Mr. Spivak.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. I've also entered the appearances of James Greger, Hunter Davis, and Ruthie Herman on behalf of the staff.
Thank you. And the Office of People's Counsel.
Good morning, Mr. Chairman. Jacob Auslander on behalf of the Maryland Office of People's Counsel, and also appearing as attorney of record is for OPC is Michael Sammartino.
Thank you, Mr. Auslander. Good morning to the utility, the Potomac Electric Power Company.
Good morning, Mr. Chairman and Commissioners. Matthew K. Seegers. I would also like to enter the appearance of Kimberly A. Curry, Douglas E. Michael, and Taylor W. Beckham. And I would also like to echo the warm welcome and congratulations to Commissioner Barve. I know I speak on behalf of all the Exelon companies, but especially the Potomac Electric Power Company. It's always good to have another customer on the commission. And we're very much looking forward to working with you.
Thank you, Mr. Seegers. We have a number of petitions to intervene that we'll now address. I would ask that the parties enter an appearance at one of the two podiums to your left or right. At that point, I will take a brief pause to see if any parties object to the party moving for party status. We'll begin with the Maryland Energy Administration.
Good morning, Michelle Honak on behalf of the Maryland Energy Administration. Also entering appearances for Steve Tolson, Sandra McLemore, and David Shapiro.
Thank you, Ms. Honing. Seeing no objections, the Maryland Energy Administration is a party to this proceeding. We'll turn to the Apartment and Office Building Association of Metropolitan Washington.
Good morning, Commissioners. I am Fran, middle initial G. Francis, appearing on behalf of the Apartment and Office Building Association of Metropolitan Washington. I would also like to enter the appearance of Etcetral K. Caldwell, EXCETRAL, Caldwell, and Catalin Peter, KATALIN. Thank you.
Thank you, Ms. Francis. Seeing no objection, AOBA is a party to this case. We'll next turn to the United States General Services Administration. Oh, you could speak from your seat if you'd like.
Thank you. Good morning. Kelly Y. Burnell, appearing on behalf of the U.S. General Services Administration. I'd also like to enter the appearance of Christy Singleton.
Thank you. Can you spell your last name, please?
Sure. BURNELL.
Thank you, Ms. Burnell. Seeing no objection, GSA is a party to this proceeding. We'll next turn to Walmart.
Good morning, Mr. Chairman, Commissioners. Stephen Lee from the law firm of Spillman, Thomas & Battle, here on behalf of Walmart. I'm not making my formal appearance today as my Pro Hoc Vice motion is in process. along with my colleague Barry Nam, but we will be notifying the commission once those are granted, presuming they are.
I suspect they will be. Thank you, Mr. Lee. Seeing no objection, Walmart is a party to this case. We'll next turn to Montgomery County, Maryland.
Good morning, Chairman, Commissioners. Lisa Brennan, Associate County Attorney on behalf of Montgomery County, Maryland. I'd also like to enter the appearance of Jim Agorzalek.
Thank you, Ms. Brennan. Seeing no objection, Montgomery County is a party to this case.
Thank you.
Good morning to the council representing Prince George's County.
Morning, Mr. Chairman, Commissioners. James McGee with the Law Office of Robert Castro on behalf of Prince George's County, Maryland. I'd also like to enter the appearance of Rhonda Weaver.
Thank you, Mr. McGee. Seeing no objection, Prince George's County is a party to this case.
Thank you.
And last but not least, counsel for the Sierra Club.
Thank you, Mr. Chairman. Good morning. My name is Susan Stevens Miller. I'd like to enter my appearance on behalf of Sierra Club. Thank you.
Thank you, Ms. Miller. Seeing no objection to Sierra Club's petition, Sierra Club is a party to this case. All right, we have a number of items to address. Let me address one of the more simple ones. Mr. Seegers, do you have an exhibit to mark?
Yes, I do, Your Honor. On June the 5th, Pepco filed our notices of publication under mail log number 303336. I would ask that this be marked as Pepco Exhibit number 1 and entered into the evidentiary record.
Any objection? Seeing none, the exhibit is marked as Pepco Exhibit number 1 and moved into evidence. I understand that staff last week filed a request for the commission to initiate a dialogue. I see that Pepco and AOBA filed responsive pleadings yesterday. Have there been any progress since these pleadings were filed in terms of a dialogue amongst the parties or between staff and the utility? Mr. Spivak, I'll let you begin.
I'm not sure I would say progress, really, but there have been some discussions that have gone on behind the scenes. We have initiated discussion with the company, or they called us, really, and also with OPC and with AOBA.
Thank you. Unlike Washington Gas, in case number 9704, that will begin shortly after this proceeding concludes, the commission has a timetable that the parties have agreed to. Is there any such document for the commission or before the commission today?
There is a timetable that Pepco filed with their application, and that is the timetable that the parties have agreed to, provided, of course, the request that I've mentioned doesn't get anywhere.
Thank you.
Mr. Chairman,
Ms. Francis, yes.
AOBA did not agree to that entire timetable. There was just one change that we wanted to make, which we can talk about later, but I am aware of the other discussions that are going on between staff, OPC, and Pepco, and I would be glad to participate in those discussions. I believe some worthwhile concepts have been discussed.
Thank you, Ms. Francis. We did review your argument that was filed yesterday. You said you had one change. Is this the first time the commission's being made aware of that change?
Yes, although I did speak to all the parties about it. The one change that I was arguing for, if this schedule goes forward the way it is, I would argue for just one brief, not two briefs. And I don't need to argue that now unless the commission wants me to.
No need at the moment.
But that was the only change. I was hoping to find a date between the initial briefs and the reply brief. So in other words, the briefs would be filed a little bit earlier than January 22nd, but there would be one brief, and AOBA was thinking of January 18th, because I know there was some sensitivity on the part of the General Counsel's office. They didn't want briefing pushed off too long.
Thank you. Our general counsel is a sensitive man. All right, we'll resolve this dispute one way or another because the clock is ticking as we speak, ever since Pepco filed back on May 16th of this year. Mr. Seegers, anything to add?
I think the only thing I would add, Your Honor, is that the company is sensitive to the burdens of having to litigate multiple cases at the same time, and we have been willing and will continue to be willing to engage with the parties to see if we can find a viable way forward that is consistent with the law. As of right now, we do not have an alternative, but the company is willing to endeavor in good faith to see if there is a way to try and alleviate the burden as much as possible. I will note that the company did include, as part of our MYP, a proposal to extend the MYP in order to try and keep this from happening again. We understand that may not address concerns about workload this year, but given the fact that we don't have a viable alternative, what the company is requesting is that we still adopt a 10-month schedule because, as you said, Your Honor, the clock is ticking and we do need a procedural schedule in the event that we are not able to reach an agreement on a viable alternative.
Thank you. Commissioner O'Donnell.
Mr. Seegers, thank you, Mr. Chairman. Mr. Seegers, you said consistent with the law with regard to timing and how sensitive you are to resources, but is a delay, a traditional delay that we've been seeing, inconsistent with state law?
A delay, I guess, on which end, Commissioner, the front end or the back end?
Implementation of the rates, which gives us an effective lengthening of the case timing.
Well, what I would say, Your Honor, is that delaying
either end, for that matter, it doesn't matter to me, but it takes the pressure off of everybody, and I just want to know if you think that's inconsistent with state law.
Well, what I will say, Your Honor, is that the timing of the filing by Pepco was not of our own volition. We were required to submit our filing when we did by this Commission's order in case number 9618, as well as the statute that accelerated or extended the review time by 300 days. So we had to make our filing in order to be consistent with the law. And if you want to extend it on the back end, well, that's inconsistent with the statute that says that the Commission is to adjudicate a rate case for an MYP within a 10-month period. So the only alternatives that have been presented to the company so far, yes, we believe have been contrary to the law. Whereas our proposal, the Commission does have the discretion to extend an MYP proposal. So that is what we are proposing.
So would you acknowledge that it's been traditional for companies filing rate cases to do that extension voluntarily? Because if you do it voluntarily, it's not inconsistent with state law. We do it all the time.
I'm not sure what voluntary extension are you referring to, Commissioner?
Normally, before we change the dates, the rate effective dates, we in statute we used to get an extra 30 days. Does that help?
Well, I'm not the party asking for the extra time, so I'm not sure the 30 days.
Someone else is, and you're saying no.
Well, Commissioner, let me ask this. Why should any utility, what staff is asking for, at least as far as the company is concerned, is unprecedented. I'm not aware of any case where a rate case applicant has been asked to waive their statutory rights right at the outset of the proceeding. So this is highly unorthodox. I just don't know why any utility should be put in that position. Moreover, and we noted this in our letter that we filed yesterday, Your Honor, there's no basis to determine which utility of the multiple rate cases that this commission has pending before it, which utility should be the one to essentially make that sacrifice?
Well, I think you were going to ask me a question, and I'm glad you didn't, because it doesn't work that way here. And you've been asking me questions throughout my line of questioning, which is not how it works, and you know that.
Mm-hmm.
2, have you had a discussion at all with staff about their thoughts on this?
Yes, Your Honor.
And they have proved non-fruitful?
So far, yes.
And can you tell me why?
Well, it's because it's because the only alternatives that have been presented to the company are not consistent with the law.
So you're putting your feet in the sand, in the concrete, and you're saying, I'm not moving, and let the proceedings be damned. We're pushing forward. So
Well,
here-
Your Honor,
which is consistent with the tenure I've heard on a lot of procedural issues from some utilities.
Well, Your Honor, I would also note that this is an MYP. This is different than a historic test year
don't-
in the sense. I'm sorry. Were you going to?
No, I know what it is. We could change it to a historic test year if you'd like.
Well, no, that is not what the company is
Well,
asking.
we have that possibility too, sir.
Yes. Well, if there is a record showing that it is just and reasonable and in the public interest, I don't believe that there is. But what I would note is that this commission approved the MRP rates for a period of 3 years. And I don't believe there is any kind of an evidentiary record that shows that those rates are just and reasonable beyond those 3 years.
There's no evidentiary record in this rate case at all, except for the exhibit you just entered this morning.
Yes, understood.
So where would one be? You say there's no evidentiary record. Where
Well-
would one be? Is it hiding in the cloud somewhere?
Well, but that's exactly what my point is, Commissioner, is
You're-
that
And you're missing my point. My point is I don't believe you've engaged in fruitful discussions with the other parties, and with all the other parties on this. That's all I have, Mr. Chairman, for now.
Mr. Seegers, you're aware of the origins of our multi-year rate pilot. BG is the multi-year rate pilot utility. We're in the midst of this process. There will be lessons learned at the very end. Is any utility in the state of Maryland entitled to a multi-year rate plan?
are they entitled to?
By right, do utilities have a right to file for a multi-year rate plan at this point in time?
I believe what the commission has said is that utilities they have the right to propose an MRP.
Correct.
If your question is, is any utility entitled to be granted an MRP? My answer is no. No, that is at the commission's discretion.
I read your pleading yesterday. You make a very compelling argument, citing the Connecticut Light case. At the same time, staff have raised some material concerns that I think the commission should review in light of the fact of five rate cases, Mr. Spivak?
That's correct, Mr. Chairman.
And I understand that the utility has a solution to fix this going forward in perpetuity.
Mm-hmm.
But obviously this doesn't provide any relief to the staff experts and other parties that may be participating in more than one case, as AOBA noted in its filing yesterday. Any response to that? Yes, you conceded that the utility, as a matter of right, does not need to be granted a multi-year rate. The commission had noted in the early BG pilot order that the commission has the ability to convert a multi-year case into a historic test year. Why should the commission not consider that as an option today?
Well, Your Honor, as the commission said in its order, that it does have the ability to modify or reject an MRP if they determine it to be in the public interest. What I would say is that I don't believe that there is a valid record showing that it would be in the public interest, Your Honor. As I mentioned before, we filed our rate case because we were complying with the law, and in the company's belief, having a utility comply with the law is always going to be in the public interest. And also having the statutory rights of not only the rate case applicant, but of every party in a rate case in a rate case proceeding is also consistent with the public interest. So, and also, I don't know what kind of review has been undertaken of the Pepco MYP application in order to determine that it is not in the public interest. So I think that is what I would say, Your Honor, is that I don't believe that there are sufficient grounds to say that it's not in the public interest.
The commission has no record, is what you're saying, to make such a determination?
Basically, yes, Your Honor.
Mr. Chairman, if I might speak just briefly. I mean, as you are aware, staff's role in a commission rate case in general is to represent the broader public interest. And our concern is that if we try to move forward with this case as it is currently configured and in the time frame that the company is requesting, which, as they've noted, is consistent with the statute, it will be very difficult for staff to present the level of analysis and review that we're accustomed to presenting, and that we want to present to the commission, and to ensure that the rates that are proposed are just and reasonable and will serve the public interest. So that's really where we are coming from with respect to our request.
And, Your Honor, if I can just briefly respond, I would note that neither staff nor OPC have made this request to any of the other utilities that have rate cases pending before this commission.
Now, you made clear the discriminatory treatment in your pleading yesterday. Mr. McGee.
Thank you, Mr. Chairman. Again, James McGee, representing Prince George's County. We did not file a letter like AOBA did. After we intervened, we received the paperwork regarding it. We do want to put on record that we support staff's request to delay. We are in a similar position as staff, also as AOBA, being involved in multiple rate cases, other proceedings before the commission that put strains on the county's resources as well. So we want to make sure that you understand our position.
Thank you, Mr. Seegers. So we've heard that from three parties saying this is a lot of work. Mr. Seegers, is it fair to say that your argument to those parties is effectively tough? We're complying with commission order. We're complying with law. The rate case has begun. The 300-day clock is ticking. Is it fair to say that you're saying tough luck to the other parties? Because you do have a strong argument. I'll concede you that.
I don't believe that's exactly what we are saying, Your Honor. We are saying that we are willing to work with the parties to see if there is a way that we can address their workload burdens in a way that is consistent with the statute. And by that, what I mean is that, is there a way that we can move around the dates within the 10-month schedule in order to try and alleviate some of the burden? I know that staff is asking that our clock does not start until, I believe, after the BGE case, which would be September 11th. Well, is there the possibility that we can move dates around to maybe not grant that much time? But what other avenues are there in order to try and get rates into effect that will, on April the 1st of next year, that will be just and reasonable? There may be a couple of different ways to get there, but right now we don't have a viable alternative.
You were attempting to answer what my next question was, and then I'll turn to my colleagues, is that if we set a procedural schedule today, then the utility has no more incentive to negotiate. But that conflicts with what you just stated, that the utility would work in good faith to perhaps move dates around. How do we move dates around if the commission sets the schedule today?
Parties can always can always agree to modify the procedural schedule, Your Honor. I've been in several proceedings where procedural schedules have been modified by unanimous consent. And, Your Honor, to address your first point, what I can say is that, as I've mentioned before, the company understands that there are a lot of burdens on a number of the parties in this proceeding. And we are not insensitive to that. And I can say that we will endeavor in good faith to try and find a viable way forward that, that works for everyone. Are we going to be able to do that? I don't know. But we will make the good faith effort.
Thank you. I turn to my colleagues. Commissioner Richard.
Thank you, Mr. Chairman. And just picking up on I think a lot of good questions have already been covered here. So let's get back to what I'm seeing the staff asking for is an accommodation. They are asking, basically they made the point that at this point there's a good argument that this is not in the public interest because they will not be able to, because of the administrative burdens, I think is what they stated in their letter, properly represent the ratepayers, properly represent, the parties, the customers. So if there were more time, do you believe that, and if you read their letter, they've offered a number of options to you as far as, granting waivers if you're truly concerned about a legal argument, a legal problem with this. Do you feel with more time you might be able to reach an accommodation with staff, with OPC, with the other parties, so that, in their view, that it would be in the public interest to move forward?
Honestly, Commissioner, I don't know. I mean, as I said before, what I can say is that we will endeavor in good faith to try and find an alternative. Am I able to sit here and guarantee that we're going to be able to reach agreement? No, of course I can't say that. So I'm not sure if that answers your question, but Your Honor, I would also say that this is not just a procedural matter. As part of our MYP, we have a number of important investments and a number of climate initiatives which we think are going to be beneficial not only to our customers, but also to achieve the state's greenhouse gas reduction goals that we would like to get in place. So that is another concern that we have about trying to push this case out. So, but to answer, I think, what the thrust of your question is, Commissioner Richard, if we have more time, I can't guarantee that we're going to be able to reach agreement. What I can say is that, speaking for the company, we will endeavor in good faith to try and find an accommodation.
Okay. Well, with MRP, as you know, and I don't want to, again, cover territory that has already been discussed, but the history is this is a pilot. We're still in the pilot phase. The commission was looking for a manner in which we could, it'd be a controlled process, would make sure that it observed administrative burdens, and also there was concern about just overlapping. So to your point, it appears that there are some public interest concerns that I think I have, and maybe other commissioners might have, that would, I think, argue for going back and trying to reach that accommodation. Mm-hmm. Do you think if we were to recess this particular matter now, give you, I don't know, would a couple of hours, a couple of days, would that provide the company some time to go back and try to reach an accommodation so that we can find some path forward with an MRP possibly to again accommodate the staff, OPC, the other parties' concerns?
Your Honor, I'm not sure if we could resolve this in a matter of hours or even a couple of days. Moreover, I would have a concern about recessing the pre-hearing conference, because if we move the date of the pre-hearing conference, I think then we might have to do renotice the conference. So I'm not sure if that would be a way forward. But again, we have engaged a couple of alternatives with staff and the Office of People's Counsel. Those alternatives have been at a very high level, and those have to be fleshed out. And I don't know if that's going to be something that we'll be able to do in the next couple of days. It may take a few weeks. So I can't say if we are even able to reach agreement, which, as I said before, I cannot guarantee this, Commission. But even if we are, I don't think it's going to be a quick process. Let's put it that way.
Okay. But, I mean, so would it be better to like a recess? I'm just trying to understand possible path forward for this commission, at least for my vote today. If we were to just to deny without prejudice and allow the company then to come back with either a historic test case or perhaps a multi-year rate plan test case that the staff could they would feel they could properly litigate. Would that be a better path forward, just to deny without prejudice?
Well, no, of course not, Your Honor. That's not what we would advocate for. I don't believe that.
Help me because I know we're just kind of dancing around now. How do we get to at least an opportunity for an accommodation with the staff and the other parties? You're saying you're not sure you can do it an hour or a couple days. Obviously, you wouldn't like the reject without prejudice path forward, but I would like to understand how we can move forward that accommodates staff and the other parties. Give me an affirmative, answer how we can do that.
Well, I'm not sure if I have an answer for you, Commissioner. I think that's why we're here today. What I would say is that we can talk with the parties, if there's the possibility of scheduling, if the commission adopts a procedural schedule today, maybe there's the possibility of scheduling a status conference or where the parties can provide an update. That's really all I can think of at this point, Your Honor, in order just to give, a date by which the parties can shoot for.
Okay. Well, the other, I don't believe we are signaling out necessarily Pepco. You recall you were given the opportunity. The company's given an opportunity in the case that resulted in Order 89868, and that was a difficult case. Would you agree? I'm sorry. This is case 9618 or the Pepco MYP? This was the previous MYP. I mean, again, I think some of the concerns I have go back to the previous, experience we had with the company, and some of the difficulties staff had that time without the concerns that they've raised in this case. So, would you agree that was a difficult case for staff and for the commission?
I would agree that there were issues in that proceeding that that I don't believe are going to be an issue in the upcoming MYP. One example that I can think of is I know that there were issues around whether or not staff had enough time to review the billing determinants.
There were staff issues. There were staff concerns raised the last time. And so I'm seeing a lot of parallels here right now, that you're not working with staff this time, and isn't it true that two commissioners dissented last time on moving forward with they rejected your rate case. Is that correct?
Our rate case was not rejected, Commissioner.
Well, two dissented.
Yes.
Okay.
Yes, there were two
and
dissents.
Were there also two concurrences that raised concerns about how you worked with staff in that case?
I believe there were, Your Honor, yes.
Okay.
And what I can say, and just going back to the specific example of the billing determinants, that was an issue in the first Pepco MYP where staff, they said that they had to ask numerous questions. They wouldn't have had time to review our materials if they had not gotten more time. in response to that, what we did is we completely overhauled how we went about our billing determinants. We worked very closely with staff on what they need to see and what we need to provide to staff. And that resulted in the DPL MYP, which resulted in a settlement. But in the specific staff testimony, their staff said what the company did, it addressed all our concerns, and they in fact said that what DPL did, which is the same process that what Pepco is using for this MYP, what staff said is that what the company did here, this is what we want to see for MYPs going forward. So I don't think that, I mean, we have been working with staff on the difficulties that came out of that first MYP, Commissioner.
Okay. Well, I don't want to take up any more time, and Commissioner Linton may have some questions as well. But I have to tell you, I have some real concerns. Again, getting into some of the, we don't have to get into all the details. I reread the case, and there, again, the fact is 2 commissioners dissented, and 2 others raised various concerns, but one area of concern was how you worked with staff and the staff concerns from the last go around. We're seeing the same thing happening right now. They're simply trying to work with the company on an accommodation. The company seems unwilling to do that, and so therefore it's really would be difficult for me to not support staff in some manner, and to the extent that perhaps it's just further discussions. But let me just leave it at that, and thank you, Mr. Chairman.
Thank you, Commissioner Richard. Mr. Seegers, just to clarify, or maybe make clear, your position is if the commission approves the procedural schedule that was set forth in your application, noting Ms. Francis's revisions, you would work to accommodate within that timetable concerns from staff, but unspecified as to how you would execute or accommodate staff. Is that?
Yes, Your Honor. That's yes. Even if the commission adopts our schedule, we will still endeavor to try and find a way that accommodates the needs of all parties.
Not impossible, but tough. Let me direct the party's attention to PUA Section 4-205. That's temporary rates, which states the commission may set a temporary rate for any public service company that is higher or lower than the rate previously in effect. Has the company or any of the parties explored this Section 4-205 as a potential fix?
Yes, we have, Your Honor. The topic has been broached with the other parties. That could be a viable path. What I will say is that I don't believe there's a whole lot of precedent associated with that statute, so it's not entirely uncharted territory, but there are a number of issues that would have to be worked out. One of which is that how do we set the rate that would be, that would put in place on April the 1st of next year? I would imagine that in order for, if we use that statute, in order for this to be really of any use to staff and OPC in alleviating their burden, we're going to have to get unanimous consent. Are we going to be able to do that? Once again, I don't know. But that is, moreover, I'm not sure if that would alleviate the commission's burden, because my understanding is that the only times that has been used, there still has to be an evidentiary hearing and briefing. So unless there was unanimous consent, Your Honor. So again, that is a topic that the that the company is very willing to try and negotiate with the other parties as a viable option. But go ahead.
Thank you. I would note, Mr. Chairman, as Mr. Seeger said, the topic has been broached. We have not really had any opportunity to discuss it in detail. I would agree. One of the issues with it is exactly, again, as Mr. Seeger said, how do you set that temporary rate, and where do you set it?
And the existing rate would not be satisfactory to Pepco, using the existing rate as the temporary rate, so effectively a continuation of your current rate in year 3 of the MRP.
Well, Your Honor, I don't believe that. I mean, again, what the rate would be, that we would have to determine that, Your Honor. As of right now, we have no record showing that the current rate is just and reasonable beyond March 31st of next year.
And I would also concur with what Mr. Seeger said with respect to there probably needs to be some level of, unless there's a unanimous agreement of the parties, there does need to be some level of evidentiary proceeding that would need to be done to establish what the temporary rate would be. At least that's what the statute certainly seems to imply.
So we would have a rate case within a rate case, is what you're saying?
Yes, although I think it would, it might be a much more truncated record.
Is there any possibility that the parties, in order to provide staff with this small, I don't want to use the word bridge period because that has a different meaning, a several month period, that the parties could see their way towards reaching consensus on a temporary rate?
I think that that's certainly a possibility, Mr. Chairman.
I see Mr. Auslander from OPC shaking his head. That's
Yeah,
affirmative.
And I've refrained, Mr. Chairman, from chiming in because questions have been directed to parties. But OPC is, we support the intent of behind staff's letter. We have had discussions with staff and the company specifically, and we've raised the issue of temporary rates under 4-205. We do agree that no viable alternative, as Mr. Seegers puts it, has been reached by today's hearing, but we do think that further discussion may be fruitful. We would share some of the concern expressed by some of the commissioners about approving the procedural schedule today, because that would essentially be approving the MYP moving forward, and probably does not create the environment for fruitful negotiation amongst the parties. We did think that perhaps one path forward would be to recess the discussion today, give the parties a couple of weeks, and maybe pick this up again at the conclusion of the administrative meeting on 6/20, as early as 6/21, or at a future date if the commission thinks that is the best path forward.
Thank you, Mr. Auslander.
Sure.
Ms. Francis.
Your Honor, I'd just like to address a couple of remarks by Mr. Seegers. I think at the outset, Mr. Seegers suggested that the only reason they filed their MYP and the date they did was a result of the Commission's order in case 9618. Now, I do understand Commission orders have the force of law. However, as the Commission well knows, you do have the ability to modify orders, to change orders, if the Commission decides to do that.
We do have that ability, although this commission, in its order, effectively told the utility to file in May of 2023. So would you concede that Mr. Seegers has a strong argument to maintain his position?
Now, I do understand the Commission did say that. I'm always forever hopeful that with certain orders, the Commission would modify certain things. However, getting on to one other point, in terms of, I haven't read 4205 in quite a while, but there is a procedure in Virginia where rates are put into effect subject to refund. It is a process that at least AOBA Virginia members are familiar with. It's not really a process that I'm totally in favor of, although we are willing to entertain something like that because that is something we are familiar with. And frequently the Virginia Commission does give very large refunds to customers. Sometimes that procedure is a little bit messy, but it can be done.
It can be done in Maryland as well. The Public Utilities article provides for refunds. It would be messy. There is a prohibition on direct refunds to customers in the law. It's not impossible. The public would experience some rate shock or a rate change.
Correct.
And it's an egg that would need to be unscrambled.
The bottom line of what I'm saying is I am not against it, and I'm willing to discuss it.
Thank you, Ms. Francis. Mr. Seegers, based on what you've heard, it appears that several parties think that there may be a viable option. I would hate to have a full-blown rate case on temporary rates. I do believe that if the parties could reach consensus for a temporary rate for, let's say, a period of, what are you looking for, Mr. Spivak, 90 days?
Yes, that's what we've asked for here as far as tolling the beginning of this time clock.
And that's 90 days or thereabouts?
Thereabouts. I mean, it was September 11th, after the close of the BGE hearings.
Mr. Seegers, I don't suggest to imply that the commission is willing to cut corners here, but I think it would weigh heavily on the commission if the parties could reach agreement, consensus on a temporary rate. If that is the case, and I recognize I haven't given my colleague, Commissioner Linton, a moment to say his piece, is this something that the Pepco would entertain, or are you sticking to the arguments you made yesterday? Is this something you want to take back to your company today, or would you ask that the commission rule today on the procedural schedule?
Well, Your Honor, I think the answer to both your questions is yes. What the company is asking for is that the commission adopt the procedural schedule, just so we have a procedural schedule in place for the current 10-month period. As to whether or not the company would be willing to entertain the temporary rates, my answer is yes. We have already raised this issue with the other parties. And again, we don't have much experience with this. And but yes, we are willing to try and negotiate an accommodation on the temporary rates.
Okay. Well, you gave me two answers there. I have your schedule before me. I think one way or another, the parties need to start moving forward, whether we have dates certain. The first one is the informational filing on June 30th, supplemental direct on the reconciliation July 14th, intervenor direct on September 19th. All right, let me let Commissioner Linton in on the game. I'm sorry for intervening. Commissioner Linton.
Thank you, Mr. Chairman, and that's perfectly fine. There was quite a few good questions already asked, but I don't think it's any secret that I was one of the two dissenters in the first MYP filing that Pepco presented to the Commission. For purposes of full disclosure, I would have dissented on the Delmarva proceeding too had it not been settled. And so as a result of the settlement, there was at least something there that was different, that we could learn a little from. We didn't have that experience with the first Pepco filing. So I guess for Mr. Seegers, I'll start with you. Good morning.
Good morning.
For my first question to you is, I hope would be a very simple one. Does the company believe you are still participating in the Commission's original pilot or not?
What I would say, Your Honor, is that
This should be a yes or no, Mr. Seegers.
we, in terms of whether or not we are the pilot utility, that would be another utility. But what I would say is that, yes, we believe that the Commission granted us an MRP, and as such, we are beholden to follow the rules and procedures that this Commission adopted in its order in case number 9618.
Thank you. So that means that as your executives that testified, right here actually, during the first MYP filing that you made, which, as I said in my dissent, was neither invited nor requested. In that filing, your executives specifically acknowledged that they were participating in a pilot, which is a learning process. So when I read your response to the staff's request for additional consideration, I was struck by the concept that there was some, I guess I'll use the word, and I'm not saying it's yours, but I'll use the word of entitlement, that this filing, this current MRP, had to continue going forward. So is it the company's position that that first pilot filing has begun establishing some precedent for future pilot filings?
What I would say, Your Honor, is that this Commission clarified in case number 9618 that, if you recall back then, there was a staff request for clarification that only one utility can file an MRP at all. And this Commission said, and it repeated the language that it originally had in the 9618 order, no, the company, any utility has a right to file an MRP. And as I discussed with the chairman, are we entitled for the commission to grant an MRP? That's a different question, Your Honor. So what our letter is intended to address is that the company has a right to come in and propose a second MRP, which would be a continuation of the first one. And as of right now, we don't believe there are sufficient grounds to say it's not in the public interest right from the outset.
So in response to the question from the chairman, you noted that following commission orders is always in the public interest. But our first order establishing this pilot didn't request a filing from Pepco or from Delmarva for that matter. I know they're not here today, so I'm not directing any questions at them. So were you not in following the public interest the first time you made a filing?
I wouldn't say that, Your Honor. I would say that your order didn't prohibit anyone else from filing an MRP.
Well, it kind of made clear that we only wanted one company. And in fact, your sister company, BGE, is the one that responded.
Well, what I would say, Commissioner, is that the commission issued an order that specifically said that other utilities are allowed to file MRPs. So I would say that this commission has actually addressed that question.
Well, we allow the other utilities to file MRPs, but that's not what Pepco filed. You filed an MRP that was specifically part of the pilot we established, where we sought for one company to participate. That's a different thing. If you just decided to file your own MRP, similar to the way other utilities in Maryland have done, that would have been different.
Mm-hmm.
But you proposed and did file an MRP to fit underneath the terms and conditions of the MRP process we established as a pilot. So, as a pilot, in the company's position, when does this pilot end? When do you think it ends?
I don't know if I can answer that question, Commissioner.
Does the company believe it ends after this filing that you just made? This will be the last MRP until the commission completes the other steps that we put in the original order setting the pilot?
Again, I don't know if I can answer that question, Your Honor.
Well, there has to be some expectation. I mean, you clearly didn't think it ended after your first MRP filing, because you made a second.
Correct.
So, and in your second one, you've proposed solutions for how the next MRP filing could be addressed. So when do you see it ending?
I don't know if, in terms of when the pilot would end, again, I'm just going to have to say that I don't know. But what I would also say is that the utilities always have the right to propose alternative forms of rate making. And if this was approved outside of the pilot, I don't think that goes away. So in order to answer your question, I think any utility will continue to have the ability to propose an MRP as an alternative form of rate making.
So the utilities have always had that ability, and other companies have done it well before the first ones were filed here amongst the IOUs that we're looking at currently. So that's not anything new. So we've always had that. You've always had that option.
Mm-hmm.
Utilities just hadn't done it. So for purposes of what we're dealing with here today, Pepco filed an MRP as part of our pilot. And so what I'm asking is it your suggestion now that our pilot should end at some point and Pepco will continue to make their own MRPs outside of the pilot?
I can't speak as to what's going to happen in the future, Your Honor.
Well, but the company's already made a filing like that. I mean, your current filing is setting up solutions for conflict issues that are existing today for the next MRP filing.
Well, Your Honor,
So you're already in the future now.
Well, yes, Your Honor. That also involves Baltimore Gas and Electric and Delmarva Power. It's anticipating. It's not just for Pepco. So, I mean, I would say, Your Honor, is that I think the company would anticipates being able to propose an MRP in the future, if that answers your question.
Well, you've always had the right to do that. I'm speaking specifically on the pilot that the executives from the company testified to as wanting to participate in. The pilot we're talking about now, that you're still in now. It seems like the company has thought through not just the current MRP filing within this pilot, but the next MRP filing within the pilot, which brings me back to my original question. Does the company believe it's entitled to MRP filings as part of this pilot or even independent of this pilot? Because one of the things the commission did say in its original order creating this pilot is that after our lessons learned process, there'd be a rulemaking structure putting in place so that we'd be able to address some of these issues that we're talking about now. So the company's already talking about the next MRP filing, which I guess is several years down the line now. So how do you say, clearly there's been some thought about not just the current MRP and the next MRP, but what happens after that?
Again, Your Honor, I know this is not a satisfactory answer, but I don't know what, I don't know what could happen in the future. I mean, as I said before, the company, I think we anticipate having the ability to file an MRP in the future.
And that ability has never changed. The company's always had that. And as I've said, not just in my dissent, but here from the bench, I'm not opposed to A4 filings. I think if there's ways to do it that are efficient and productive in the public interest for our staff, the advocate organizations, and the utility companies, then that's fine. I'm looking forward to seeing those efficiencies. But from what we've heard from our staff today and what we heard from our staff at the last proceeding that we had for Pepco, we haven't had all of those efficiencies. So I'll walk away from the pilot conversation and address the second suggestion that was raised regarding these conversations that are happening amongst the parties. And I'm not going to go too far into this because this is a preliminary hearing and we just have your filings on the record. There isn't much more about it here at that point. And I may actually direct my questions to the People's Council and to our technical staff first. The company in its filing did suggest some future modifications for future MRP filing. So I'm not asking you for your critique of it or your analysis of it, but I am curious as to the extent of the conversation that occurred before the filing was made. It did not appear to me that it was characterized as a joint filing. Is that fair to say?
That's correct, Commissioner.
Okay, and I don't want a lot of analysis of it. I just wanted to make sure I understood that this was not a proposal or a solution to the challenge of stacking rate cases, which is something that this commission has been concerned about since we were all in Annapolis debating the possibility of a statutory change to accommodate A4s.
It's been characterized as that by the company. That is an attempt to prevent the sort of stacking of rate cases that we're dealing with at the moment, or at least make it easier to deal with. And at least on its face, it may appear to do that, but we haven't had the chance to really analyze it thoroughly and determine whether we think that would at least alleviate the problem. We just haven't gotten there yet. And it, as was been pointed out, it does it for the next case, but not this one.
Well, thank you, Mr. Spivak. And again, I'm trying to make sure I don't get kicked under the table by our general counsel. I'm not trying to go too far into the details of that. I really wanted to make sure I understood that this was not a proposal that included consultation with the technical staff about how to solve this solution that would directly impact the technical staff. I mean, this is a challenge that our staff has pointed out for you, and for you on behalf of all five of us as commissioners. So the solution was proposed to our staff, and there were other words I would use in addition, aside from proposed, which I won't for purposes of my colleagues here today, but it was told to you.
That's correct. I mean, the company brought that proposal to us as part of essentially their pre-filing briefing of the case.
And for the People's Council, is that also the same?
I would agree with Mr. Spivak. That's accurate, and I'd just like to point out that a lot of these problems that led to Pepco making this proposal were caused by their decision to file the initial.
You get no disagreement from me on that one, but so just to be clear, then the company presented these solutions to you, but didn't consult you on whether or not it was the best solution going forward that would work for you.
Well, I mean, when the company presented this to us, our response was, that's fine for the next case, but it doesn't do us any good now.
And that was the same remarks that OPC had made.
Okay.
If I might, there is one other thing, and just this notion that we've somehow singled Pepco out here.
I was getting around to that one, but go ahead.
Well, no. I mean, they've kind of singled themselves out. I mean, out of the rate cases that were filed in quick succession at the end of last month, theirs is the only MYP. There's the only MYP with an affiliate. Theirs is the case that places the most burden on the parties. The other cases are historical test year cases. They're generally simpler. The amounts at stake are generally lesser, and none of those other companies have affiliates who are currently in the middle of an MYP. So, I mean, if you're going to seek to have a burden relieved, you probably want to lift it to the greatest extent possible, and that is this case.
Your Honor, if I may respond to that, I would note that a number of those other rate cases are before a PULJ, and they have much shorter time frames than we do in this case. So I would imagine if there's a burden, that it may be there than rather than here.
Well, Mr. Seeger, certainly the burden for the five of us up here, and perhaps for our senior advisors, is lifted when it is presented to a PULJ. But for our technical staff, the same, quite frankly, excellent employees that we have that sit on that side of the table for rate cases before the five of us are also the same ones in front of the PULJ. And I might add, for the People's Council, for AOBA, and for any of the other parties that participate here, the same would go for them. Utilizing the PULJ really isn't a solution to this problem, even though, like I said earlier, it might free up an afternoon for us, as the five of us, but it does not resolve the challenge that the technical staff faces. So Mr. Spivak stole a little bit of my thunder for purposes of questioning this issue of singling out Pepco. I think that he's raised it in the way that was appropriate. So I'll pause at this point, Mr. Chairman. I think the only thing I've said before, and I said I didn't want to be right about any of this when I dissented. I was hoping that it wouldn't come to this point. But I'll note, just for here today, that throughout the course of our learning of this, all of the commissioners, including our Commissioner Emeritus, Commissioner Herman, all of us raised concerns about the impacts of MYPs on our technical staff and the parties as a whole. And it's the reason why we took the approach of starting with a pilot. And when I think back to where we are today versus where we were back when we first debated and ended up moving forward with this pilot, had we gone forward with it with only one company as we originally proposed, today we would have already had one MYP filed. We would probably be looking at regulations that included performance incentive measures and all the other solutions that are important to having very productive MYPs that would work in the public interest, as opposed to having a proceeding today where a regular status conference ends up having motions and challenges of this nature. And we're trying to figure out if the pilot should even be continued and how do we solve these other compounding problems. And we still have to deal with all of those regulatory challenges going forward. At least maybe some of us have to deal with those going forward. So I guess for myself individually and to the staff, I apologize to you guys for that, because you shouldn't have had to deal with all of this. This is something that should have been done better. We should have gotten this right. And I wish, I don't know if I could have made a stronger argument, but you know, there should have only been one, in my opinion. And that's just for me. You know, I'm certainly not speaking for the bench. And I apologize to Commissioner Varve for hearing all of this on his very first AM. So, thank you. Thank you, Mr. Chairman. That's all I have.
Thank you, Commissioner. This is not the best first impression day for Commissioner Barve as he attempts to figure out what we're debating here.
I've lived through worse.
No, you haven't seen anything yet. Commissioner O'Donnell?
Just a couple context observations, Mr. Chairman, and then I'll have a question for the Office of People's Counsel. One, I agree strongly with the notion that the reason we set up a pilot was so that we could develop subsequent regulations based on lessons learned and look at this newly plowed, not previously plowed ground and see where the movable rocks were and where the immovable rocks were, and what we needed to do to set up a fair process that didn't single out anybody. Some utilities didn't allow us to do that. And I want to stress that. Some utilities did not allow us the opportunity to do that. And we can't stop a utility from filing. We cannot. I acknowledge that, and I agree with that. But I also acknowledge that we have other options if we find that the proposal is not in the public interest. So I wanted to say that by way of context. We're not singling anyone out. We have endeavored greatly not to single anyone out. We just haven't quite been given the space to figure that all out yet. One. Two, over the years, I've heard OPC. If I've heard them once, I heard them a million times, like we're getting into rate case money, or in terms of how many dollars it is, as to not having the resources to fully analyze, complete their analysis, do a good job, do the best they can. We took a swag at this, we took a swag at that, but we have 12 people, permanent staff, and we haven't had the ability to do this. And yet, this MYP, which, by the way, did come down with a 3-2 vote, which did, by the way, have 2 concurrences, which in my opinion were much more brutal than the dissents. Much more brutal. They were. And having been in that process, that I wasn't one who opined. I didn't opine one way or the other. There were 2 dissenters, 2 concurrences. Dissents were tough, but concurrences were brutal. And I don't say that pejoratively. I'm just saying what I read. I didn't write, but people may not, without giving up any deliberative confidences, I hope, are not, maybe I'm seeing an indication here that some people don't understand how close it was to being denied. Because it was damn close. I mean, within a cat's whisker. And I don't hear that being reflected in some type of cooperative discussion here today, and that's troublesome for me. Now, Mr. Auslander, Office of People's Counsel seemed kind of muted in their support. We heard a little bit from you. We support generally staff's position, but this case is going to raise consumer rates significantly. And since you've made a little cottage industry of saying we haven't had enough time to fully analyze this stuff, or we would have did better on behalf of the ratepayers, could you put a little more passion into your support, please? Because I don't think we've heard it, and it seems like you're laying back for reasons not clear to me.
Well, if that's the impression, Commissioner O'Donnell, I apologize for my demeanor. We do we're very concerned about the level of rate increase that Pepco has included in its application for this second MYP. We've also been critical of MYPs in general, and we shared concerns reflected in those concurrences and dissents, and positions taken in those cases, and they continue to be the concerns that the Office of People's Counsel has. We also, recognize that, as Mr. Chairman pointed out, that the company's filing this time around was explicitly called for at second MYP. So, we are certainly going to participate in this case, notwithstanding our concerns. But we do believe that the learning process that was contemplated in the original MYP filed by BGE has not taken place, that we don't have the regulations that I think the Commission intended to have in place before additional MYPs were filed. And unfortunately, now we are in a situation where we are doing the best we can with the resources that we have to deal with this second MYP filed by Pepco, and we support, as I mentioned, the intent behind staff's request that some relief be granted by the Commission, and I think that there's different ways that could happen, and I think some of them have been talked about today, and our position unequivocally today is that we would ask that the Commission not approve the procedural schedule and instead either provide the parties more time to move forward or to make some decision that would really alleviate the burden that will be caused if Pepco's MYP moves forward as filed.
We expressed some distaste on the part of OPC for MYPs, but it's a statutory requirement. It's passed by the legislature. We're implementing the law, and that's our job. So we're going to continue to do that. However, having said that, we need to be able to make a case in the public interest, and this is the second one from this utility, and you can do a stellar job in learning lessons or incorporating learnings to the extent we had even quantified them, but I hear the same kind of attitude about where this is going to go, and I'm increasing. I come into this room not knowing what I was thinking about this. To be honest, I wanted to hear the arguments, but I'm becoming increasingly concerned that there may be a lack of fealty to the public interest buried in this intransigence, or my perceived intransigence. So I'll leave it there, Mr. Chairman, but I'm concerned, and my concern is not lessened as one who didn't opine in the previous rate case.
Thank you, Commissioner. Some of you may remember last year when we had the DPL scheduling conference, I was cranky because it lasted more than about 20 minutes, and now we're at an hour and 20 minutes on this case. These should be relatively simple. This is not the case here. Mr. Seegers, you are the moving party. We have your procedural schedule in front of us. So there's two doors you could open, door number one and door number two. Door number one I would describe as we discussed probably about 45 minutes ago, having some additional time to speak to the parties, knowing that the filing started the kickoff of the clock with each passing day. Number two is you requesting the Commission to take action today. I don't know what that action would be. We would likely recess and come back with a determination on your proposed schedule. As the kids say nowadays, there's a vibe, and I feel a vibe on this bench with respect to the request being made today. So using your skills and instincts, and based on what you heard today from the discussion with the commissioners, I would ask you, Pepco, do you seek some additional time to discuss with the parties, or would you like the Commission to rule on your application and schedule right now?
Your Honor, I think it would be beneficial for the parties to have some additional time in order to see if we can reach some kind of accommodation. I will say that regardless, we will still abide by the dates that are in this. For example, the June 30 annual information filing. We will still abide by those dates in this procedural schedule. So, but I think it would be beneficial to have some additional time, Your Honor.
All right, you can abide by, because the first few dates apply to you, the utilities, so you
Correct.
can do whatever you want. It's not a blessing or confirmation of this commission that this would be the official schedule going forward. But the next two dates, well, the suspension period does end on June 16th, absent action by the commission. The filing will be made by Pepco on June 30th. Supplemental direct will be made by Pepco on July 14th. After that, all bets are off. The commission is not directing today that intervenor direct be filed in September. Commissioner O'Donnell?
Thank you, Mr. Chairman. Without belaboring the point, Mr. Seegers, I didn't just hear you say we're going to press forward with what we propose, and it's going to be our way or the highway, damn it, and that's where we're heading. Please tell me you didn't just say that.
I'm not saying that, Your Honor. I hope I've made myself and the company's position clear that we will endeavor in good faith to try and reach accommodation, Your Honor.
All right, Mr.
All right, well, sorry, Mr. Chairman, when I hear that language, we're proceeding with what we submitted. And I understand the first two, I understand the chairman's clarification, and I agree with that, but it's more of an indication that I'm not sure how fruitful 2 weeks of discussion is going to be.
Mr. Seegers, you will effectively be driving this bus. I don't know how much time you would need to either return to the commission and let us know that you've reached an impasse, or perhaps the suggestion to employ Section 4-205 may bear some fruit if all of the parties, and I emphasize all, how many parties do we have now? We have like 9 parties, agree to temporary rates. That's just one of many suggestions. We won't set a date now, but if you confer with the parties and wish to be in touch with the Executive Secretary's office, we could find a date in the not-too-distant future to bring this back.
Understood, Your Honor.
All right. Thank you, Mr. Seegers. Any of the other parties wish to... All right, we are adjourned in case